Welcome to the twilight zone of jurisprudence, a place where common sense goes to die and the fine print reigns supreme. We like to imagine the law as a marble statue, rigid, blind, and just. But peel back the curtain, and you'll find it's more like a game of Twister played by bureaucrats in a hall of mirrors. From rewarding burglars for their clumsiness to recognizing too rich to care as a medical condition, we have curated a collection of 50 real legal anomalies. These aren't just mistakes, they are the trapdoors in the floor of civilization. Buckle up. We are crossing the border between justice and madness. 1. The Fight Club Clause. Mutual combat. Most of us assume that if two adults decide to pummel each other into hamburger meat on a public street, the police will intervene. In Washington State and Texas, however, officers might just have to pull out some popcorn. This is the doctrine of mutual combat. It is a legal relic suggesting that if two parties willingly consent to a fistfight, it isn't assault. It's just a very aggressive disagreement. The law essentially shrugs and says, if you want to concuss each other, who are we to stop you? It turns street brawls into sanctioned sporting events, provided everyone agrees to the terms before the first tooth flies. 2. The Cowardice Mandate. Duty to retreat. In the cinema of your mind, self-defense is heroic. In the legal codes of many states, however, heroism is a liability. The duty to retreat doctrine dictates that before you defend yourself against a violent attacker outside your home, you must first attempt to run away. You are legally obligated to check for exit routes, assess your cardio levels, and flee like a gazelle before raising a fist. If you stand your ground when you could have sprinted, you, the victim, could be charged with assault. It is a bizarre inversion where the law demands you prove your cowardice before it allows you to fight for your life. 3. The robot defense, automatism. Cut to a courtroom where the defendant admits to the crime but claims their brain was on screensaver mode. This is automatism, a defense arguing that the accused was moving but not actually there. We aren't talking about daydreaming. We're talking about sleepwalking murderers or drivers having seizures. The legal theory posits that without a conscious mind piloting the meat suit, there is no guilt. It allows for a scenario where a person can violently dismantle a window or a neighbor, only to wake up and legally say, "Wasn't me. It was the autopilot." It is the ultimate disconnect between action and accountability. 4. The Good Samaritan Trap, liability. You see a stranger choking in a restaurant. Your instinct is to help. The law's advice? Pause and check your bank account first. In jurisdictions without robust Good Samaritan laws or with Good Samaritan liability, trying to save a life can get you sued if you accidentally crack a rib or bruise an ego in the process. This legal perversion incentivizes monstrous indifference. It creates a society where the safest legal move is to step over the dying man and finish your latte, because trying to be a hero might just cost you your house. 5. The burglar's jackpot, duty of care. Imagine, a professional thief breaks into your home to steal your television. Now imagine he trips on a loose carpet runner and sues you for his twisted ankle. This is the duty of care applied to trespassers. In certain jurisdictions, your property rights do not absolve you of the responsibility to maintain a safe environment for everyone, including the people actively trying to rob you. It transforms the victim into the negligent party and the criminal into a plaintiff. It is a legal loophole that suggests if you're going to have a burglar, you'd better make sure your staircase is up to code first. 6. The slow-motion heist, adverse possession. There is a way to steal a house without a gun or a ski mask. You just need patience. Adverse possession, colloquially known as squatter's rights, allows a trespasser to become the legal owner of a property simply by occupying it openly for a set number of years. It is the legal equivalent of calling dibs and waiting out the clock. If the original owner doesn't notice the stranger living in their guest room for a decade, the law eventually hands the squatter the deed. It's a transfer of wealth that rewards the most audacious kind of pestilence. 7. The subscription service, Florida shoplifting. Florida's theft laws inadvertently created a loyalty program for criminals. By distinguishing petty theft from felonies based strictly on a dollar amount per incident, the law allows a disciplined thief to rob a store every single day, as long as they stay under the limit. It is a crime subscription service on the misdemeanor tier. A smart criminal can amass a warehouse of stolen goods over a year, but because they did it in bite-sized chunks, They never face the felony charges that a single large heist would trigger. It is bureaucratic efficiency weaponized against retail. 8. The Handshake Hustle, Statute of Frauds. Grifters love the Statute of Frauds. This ancient legal rule requires certain contracts, like land sales or high-value goods, to be in writing to be enforceable. For a con artist, this is a license to lie. They can make a grand verbal promise, shake your hand with tears in their eyes, take your money, and then legally pretend the conversation never happened. Without the paper trail, the court system acts like a bouncer refusing entry to the truth. It is a harsh lesson that, in the eyes of the law, a gentleman's agreement is worth less than the invisible ink it isn't written in. 9. The corporate masquerade, the corporate veil. Corporations are people in the eyes of the law, but they are people who cannot be handcuffed. This is the corporate veil. It separates the company's liability from the humans running it. Executives can make decisions that poison rivers or bankrupt towns, yet when the lawsuits come, they sue the entity. The company declares bankruptcy, the shell collapses, and the executives parachute out with their personal fortunes intact. It is a magic trick where accountability vanishes into a filing cabinet, leaving the victims to chase a ghost. 10. The offshore Houdini, asset protection. For the ultra-wealthy criminal, losing a court case is just a suggestion. Through asset protection trusts and offshore shell companies, a fraudster can hide millions in complex legal labyrinths. They might be ordered to pay restitution to their victims, but on paper, they are destitute. The money is sitting in a Caribbean account that U.S. courts can't touch. It turns justice into a farce, where the winner of the lawsuit gets a piece of paper, and the loser gets a margarita on a beach in the Caymans. 11. The escape artist, German prison law. In Germany, the desire to be free is considered a fundamental human instinct, not a crime. Therefore, breaking out of prison is not in itself illegal. If a prisoner scales the wall without hurting anyone or damaging property, they face no additional sentence for the escape. It's a philosophical flex that seems insane to the American mind. The law essentially tells the prisoner, "We have to keep you here, but we don't blame you for trying to leave." It's a system that respects the soul of the escapee, even while it cages the body. 12. The polite lifer, Swiss sentences. Switzerland treats incarceration less like a dungeon and more like a stern rehabilitation retreat. There is technically no life without parole. Even for the most heinous acts, the maximum sentence usually caps around 15 to 20 years. The cultural philosophy is that no human is beyond redemption. It creates a reality where a monster can commit unspeakable acts and still have a guaranteed checkout date, returning to society while their victims are still mourning. It is civilization betting its safety on the power of a second chance. 13. The diplomatic untouchables, immunity. Diplomatic immunity is the ultimate get-out-of-jail-free card, gold-plated and internationally recognized. High-ranking diplomats and their families can treat the host country's laws as mere suggestions. From unpaid parking tickets to legitimate theft or assault, local police are often powerless to arrest them. The worst punishment they face is being expelled from the country. It creates a caste of untouchables who can rampage through a city, protected by a treaty that values international politeness over local justice. 14. The paper terrorists, sovereign citizens. Enter the sovereign citizen, a person who believes they have discovered the cheat codes to the legal system. They argue that they are not subject to government authority, often citing obscure, misinterpreted maritime laws. Their defense strategy is paper terrorism, burying the court in mountains of nonsensical filings written in a pseudo-legal dialect. While they rarely win, they can gridlock the system for months, exhausting judges and prosecutors. It is a denial of reality so aggressive that it forces the legal system to waste thousands of hours trying to explain that laws are, in fact, real. 15. The wild card, jury nullification. This is the secret weapon of the jury box. Jury nullification occurs when a jury believes a defendant is guilty according to the facts, but decides to acquit them anyway because they dislike the law itself. It is the ultimate veto power of the people. A jury can look at a clear-cut case and say, "We don't care." It can be a tool for mercy and unjust laws, or a tool for prejudice, letting a popular criminal walk free. It is the ghost in the machine of justice, proving that 12 random people are more powerful than the entire penal code. 16. The tainted orchard, fruit of the poisonous tree. If a police officer breaks the rules to find evidence, that evidence is the poisonous tree. Anything discovered because of it, the murder weapon, the ledger, the body, is the fruit, and it must be thrown out. A cop could find a map to the bodies during an illegal search, but because he didn't have the right warrant, the jury is forbidden from seeing it. It is a procedural purity test that often results in the guilty walking free, to teach the police a lesson about paperwork. 17. The script of silence. Miranda writes, "You have the right to remain silent." We know the lines, but the power lies in the delivery. If an arresting officer stumbles over these words, forgets a phrase, or delivers them at the wrong moment, an entire confession can be erased from the record. A serial killer could give a tearful, detailed admission of guilt on camera, but if the preamble was botched, it's legally treated as if he were discussing the weather. It is the ultimate triumph of form over substance. 18. The broken link, chain of custody. Evidence in a trial is only as good as its travelogue. This is the chain of custody. Every second a piece of evidence exists, its location must be documented. If Officer Bob leaves the bloody knife on his desk while he goes for a donut and forgets to log it, that knife is legally compromised. A defense lawyer can argue it could have been tampered with, and the judge might toss it. It's a technicality that allows mountains of proof to be dismantled by a single moment of clerical laziness. 19. The manufactured crime, entrapment. There is a fine line between catching a criminal and creating one. Entrapment occurs when law enforcement doesn't just provide an opportunity for a crime, but actively coerces or persuades someone to do it. If an undercover cop has to badger, beg, or trick a person into selling drugs they didn't have, the law says that's not a crime. That's a setup. It protects citizens from overzealous police who are so desperate to fight crime they decide to write the script and direct the scene themselves. 20. The Typo defense, defective warrants. The Fourth Amendment is a stickler for details. A search warrant gives police the power of God to enter a home, but only if the paperwork is flawless. If the warrant lists the address as 123 Elm Street, but the suspect lives at 125, or if the name is misspelled, the entire raid can be declared illegal. The police could find a meth lab in the basement, but because the judge's secretary made a typo, the search is void. It is the only place on earth where a spelling error can save you from 20 years to life. 21. The gossip filter, hearsay. The courtroom demands first-hand accounts, creating the hearsay rule. You cannot testify to what someone else told you. You can only say what you saw. While logical, it creates absurd blind spots. A witness could say, "The defendant's best friend told me he confessed," and the judge will likely silence them. It protects the court from rumors, but it also filters out potential truths that come secondhand. It turns the trial into a game of telephone, where only the first whisper counts. 22. The marketplace of truth, expert witnesses. If the facts don't fit your narrative, simply buy new facts. In high-stakes trials, wealthy defendants can hire expert witnesses to testify to almost anything. For a fee, you can find a credentialed scientist who will argue that gravity is a suggestion, or that the DNA evidence is actually aggressive mold. It turns the courtroom into a marketplace where scientific truth is up for auction, and the jury is left trying to decide which paid actor sounds more convincing. 23. The sound of silence. Pleading the Fifth. The Fifth Amendment is the only time I refuse to answer is a valid legal strategy. It protects a defendant from self-incrimination. You can sit on the stand, look the jurors in the eye, and refuse to explain why your fingerprints were on the safe. Legally, the jury isn't supposed to interpret this silence as guilt. Practically, it's the most suspicious thing a human can do. It is a constitutional right that feels like a playground taunt. I know, but I'm not telling. 24. The one-shot rule, double jeopardy. The government gets one bite at the apple. Double jeopardy means you cannot be tried for the same crime twice. If a prosecutor fumbles the case and you are acquitted, you are bulletproof. You could walk out of the courthouse, write a book titled, "How I Did It," and the state can't touch you for that offense. It prioritizes the finality of the legal process over the actual truth, ensuring that a mistake by the state is a permanent victory for the accused. 25. The Bazaar of Justice, plea bargaining. Forget the dramatic trials you see on TV. 90% of American justice happens in a back room via plea bargaining. It is a haggling session where the prosecutor offers a discount sentence in exchange for a guilty plea. Admit to the robbery and, well, drop the assault charge. It's efficient, sure, but it turns justice into a transaction. It pressures the innocent to plead guilty to avoid risk and lets the guilty off easy to save the state time. It is the fast food drive-through of the legal system. 26. The paradoxical confession, Alford plea. Imagine standing before a judge and saying, "I didn't do it, but I accept that you have enough evidence to lock me up, so punish me anyway." This is the Alford plea. It allows a defendant to maintain their innocence while accepting the legal consequences of guilt. It's a face-saving maneuver that lets the system close the case without ever getting a true admission. It is a Schrodinger's cat of justice, where the defendant is simultaneously guilty and innocent, depending on who you ask. 27. The hourglass of guilt, statute of limitations. Time heals all wounds, and apparently, it also erases all crimes. The statute of limitations sets a deadline for prosecutors. If they don't charge you within a certain number of years, for most crimes, you are free. You could have stolen a Rembrandt or embezzled millions. But if you can just lay low in a hammock until the clock runs out, you can return home and frame the receipt. It's a law that treats criminal liability like a carton of milk. Eventually, it just expires. 28. The memory hole, expungement. Expungement is the legal delete button. It allows a person to have their criminal record sealed or destroyed, effectively behaving as if the crime never happened. They can legally lie on job applications and say they've never been convicted. While intended for second chances, it allows career predators to present a virgin slate to the world. It is state-sanctioned gaslighting, asking society to pretend that the past is just a figment of our imagination. 29. The violent reset, sealed juvenile records. The law treats anyone under 18 as a distinct species capable of magical moral regeneration. Juvenile records are often sealed instantly upon adulthood. A teenager could have a history of violent assaults, but on their 18th birthday, the record vanishes. An employer or university has no way of knowing they are dealing with someone who spent their adolescence treating the Geneva Convention as a checklist. It protects the future of the child by blinding the society they are re-entering. 30. The judge lottery, sentencing disparity. Justice is supposed to be blind, but it turns out she's just moody. Sentencing disparity reveals that two people can commit the exact same crime, but receive wildly different punishments based solely on which judge they drew. One gets probation, the other gets 10 years. It depends on the judge's breakfast, their politics, or the defendant's tie. It strips the law of its predictability and turns sentencing into a game of Russian roulette. 31. The slow-motion escape, speedy trial violations. The Constitution guarantees a speedy trial. Paradoxically, delays are a criminal's best friend. A defense team can file endless motions to drag the process out. If the delay becomes unreasonable and the fault lies with the state, the judge can dismiss all charges. The defendant walks free not because they are innocent, but because the calendar moved too slowly. It is a strategy of weaponized boredom, defeating the justice system by simply waiting for it to fall asleep. 32. The Seinfeld law, duty to rescue. In most U.S. states, you have no duty to rescue. You can watch a blind man walk into traffic or a child drown in a shallow pool, and legally, you can just stand there and finish your sandwich. As long as you didn't cause the danger, you are not obligated to help. It protects the crime of monstrous inaction. The law distinguishes between doing harm and allowing harm to happen. A moral hair-splitting that lets sociopaths sleep soundly at night. 33. The heavy shield, presumption of innocence. Innocent until proven guilty is the bedrock of the system, but it is also a massive tactical advantage. The defendant doesn't have to prove anything. They don't have to speak, explain, or justify. The state must do all the heavy lifting to cross a very high bar of certainty. If there is even a sliver of reasonable doubt, the accused walks. It is a system designed to let 10 guilty men go free rather than imprison one innocent man. A statistic that criminals rely on every single day. 34. The rich kid disease, affluenza, In a case that boiled the blood of a nation, a defense team argued their teenage client shouldn't be jailed for a deadly DUI because he suffered from affluenza. The theory: he was so wealthy and spoiled that he was incapable of understanding consequences. And it worked. He got probation. It established a precedent that privilege is a disability, and having too much money is a valid excuse for killing people. It is the moment the legal system took off its mask and winked at the 1%. 35. The Pillow Talk Vault. Spousal privilege. Marriage is a bond, but in court, it's a bunker. Spousal privilege generally prevents the state from forcing a person to testify against their spouse regarding confidential communications. The one person who knows where the bodies are buried, the partner who washed the blood off the shirt, can legally remain silent. It values the sanctity of matrimony over the demands of justice, essentially granting every criminal one safe harbor in the form of a wedding ring. 36. The confessional black hole. Clergy privilege. There is one place on earth where secrets are truly eternal: the confessional. The clergy penitent privilege ensures that a priest, rabbi, or minister cannot be forced to testify about a confession. A murderer can unburden his soul, describe every grisly detail, and the religious leader is legally gagged. It turns a spiritual ritual into a perfect evidence incinerator, placing religious dogma above the safety of the community. 37. The granny whisperer. Undue influence. Getting into an elderly person's will is a subtle art. Undue influence describes when a caregiver manipulates a vulnerable person into changing their estate plan. But proving it is a nightmare. The predator isolates the victim, feigns love, and by the time the family finds out, the loving caregiver owns the house. The law struggles to differentiate between genuine late-life affection and a slow-motion con job, often leaving the inheritance in the hands of the person who hid the dentures. 38. The snitch's paradise. Witness protection. The Witness Protection Program is a loyalty reward scheme for betrayers. If a career criminal agrees to rat out his boss, the government washes away his past. They give him a new name, a new home, and a stipend, all funded by tax dollars. You could be a hitman one day and a suburban dad named Bob the next. It's a utilitarian calculation that says, we will forgive your lifetime of sin if you just give us the bigger fish. 39. The Thieves' Guild dispute. Criminals suing criminals. The courts are open to everyone, even those who mock the law. A criminal can theoretically sue his partner in crime for breaching a contract related to their illegal enterprise. While a judge will likely throw it out, citing unclean hands, the fact that the system must entertain the filing is absurd. It imagines a world where a getaway driver sues for unpaid mileage reimbursement. It destroys the myth of honor among thieves and replaces it with litigation among thieves. 40. The confusion grenade. Chewbacca defense. When the facts condemn you, confuse the jury. This is the Chewbacca defense, a strategy of introducing so much irrelevant, complex, or emotional noise that the jury loses the thread of the argument. The goal isn't to prove innocence, it's to induce cognitive failure in the 12 people deciding your fate. If the jury is too baffled to agree on a verdict, the defendant wins. It is the weaponization of nonsense. 41. The Trap House. Castle Doctrine. The Castle Doctrine says you can defend your home with lethal force, but in the hands of a psychopath, it's a license to kill. A clever aggressor can lure an enemy onto their property, provoke a fight, and then shoot them dead the moment they cross the threshold, claiming self-defense. It twists a law meant for protection into a mechanism for premeditated murder, using the property line as a kill zone. 42. The Mind Gap. Insanity defense. Similar to automatism but deeper, the insanity defense argues that the defendant was so mentally ill they couldn't distinguish right from wrong. It's a high bar, but if cleared, the accused skips prison for a psychiatric facility. The loophole? If doctors later deem them cured, they can be released years earlier than a prison sentence would allow. It treats the crime as a symptom of a temporary illness, rather than a permanent act of evil. 43. The oops defense, mistake of fact. I didn't know I was stealing it. This is the mistake of fact defense. If you genuinely believed the umbrella you took was yours, there is no crime because there was no criminal intent. While logical for umbrellas, it gets murky in complex fraud cases. A CEO can claim he simply didn't understand the financial regulations he violated. It forces the jury to read the defendant's mind, a task that usually ends in a shrug and an acquittal. 44. The rage discount. Heat of passion. The law has a soft spot for anger. The heat of passion defense can reduce a murder charge to manslaughter if the killing was done in a sudden, uncontrollable rage caused by provocation. It's a discount coupon for homicide. It suggests that killing someone because you were really, really mad is somehow less morally reprehensible than killing them calmly. It validates loss of control as a mitigating factor. 45. The bankrupt millionaire. Bankruptcy fraud. Bankruptcy is meant to be a safety net, but for some, it's a strategy. A strategic bankruptcy allows a debtor to wipe out liabilities while preserving exempt assets, like a primary residence or retirement accounts. A person can ruin countless creditors and contractors, declare Chapter 7, and still retire to a Florida mansion that the law says they get to keep. It is a legal way to say, sorry, I'm broke, while sipping champagne. 46. Too small to fail. De minimis. De minimis non curat lex. The law does not concern itself with trifles. This principle means courts won't bother with tiny infractions. For a petty criminal, this is a green light. You can steal items of negligible value or commit minor nuisances, knowing the prosecutor won't waste the budget to stop you. It effectively legalizes low-ambition crime, creating a zone of lawlessness just below the radar of the state. 47. The broken mind, competency. Before you can be tried, you must be competent to stand trial. You must understand what is happening. If a defendant is found incompetent due to mental illness or disability, the trial freezes. They are sent to a hospital, not a prison. If they never regain competency, they are never tried. They exist in a legal limbo, potentially for life, but they never face the verdict of guilty. It is a purgatory that avoids the finality of justice. 48. The privacy shield. Fourth Amendment nuance. The Fourth Amendment protects privacy, but it often protects secrecy. If you have a reasonable expectation of privacy in a place, police need a warrant. This extends to locked phone contents, high-tech surveillance, and thermal imaging. While vital for liberty, it creates dark corners where crime can fester, protected by the digital equivalent of drawn curtains. It ensures that the most sophisticated criminals are the hardest to look at. 49. The free pass grandfather clauses. New laws usually don't apply to old buildings or actions. These grandfather clauses allow dangerous electrical wiring, environmental pollution, or unsafe structures to exist simply because they were there first. It's a legacy loophole that says it would be illegal if you did it today, but since you did it yesterday, carry on. It values continuity over safety, letting the ghosts of the past dictate the standards of the present. 50. The Hall of Mirrors, civil forfeiture. We end with a twist, a law that makes property the criminal. In civil asset forfeiture, police can seize your cash or car if they suspect it was involved in a crime. They don't have to charge you, they charge the cash. The case will be titled State of Texas v. $5,000. To get it back, you must prove the money is innocent. It flips the presumption of innocence on its head, allowing the state to rob the citizen legally. It is the perfect finale to our list, a law that doesn't just protect the criminal, but turns the government into one. Conclusion. And there you have it. 50 cracks in the windshield of justice. In the grand theater of human folly, these laws remind us that the system isn't a divine machine. It's a patchwork quilt stitched together by fallible humans, panicked legislators, and very expensive lawyers. From the squatter sipping tea in your living room to the diplomat speeding away from a crime scene, the line between legal and right is often measured in the quality of your attorney. It leaves us with an uncomfortable question. If the law can protect the guilty so effectively, who is it really designed to serve? Perhaps justice isn't about truth at all. Maybe it's just about who reads the rule book the closest. Now, we turn the jury over to you. Which of these loopholes made your blood boil, and which one would you secretly use if you had the chance? Let us know in the comments. Case dismissed.